Assalamualaikum warahmatullahi wabarakatuh. This is our group assignment 2 by group 11 on court case of environmental crime. The presenter will start with Nurul Anis binti Zahari, Muhammad Ari bin Yasin, and last Balkis binti Ismail. Introduction for local case 1. Food and beverage product companies discharge industrial effluent in excess of standard limits. For the case overview, December 26, 2000 at Shah Alam, the Selangor State Department of Environment DOE has informed that the food and beverage processing plant Nestle Manufacturing Malaysia Sdn Berhad has been charged in court with 2 charges under the Environmental Quality Act, Industry Effluent Regulation 2009 for failing to comply with the standard limits set out in the same regulation according to the chart read out by the court interpreter on May 21, 2019. The company was found to have discharged industrial effluent in excess of the standard limit for 5 parameters under regulation 11(1)B Environmental Quality Act, Environmental Industrial Effluent Regulation 2009. At the background cases, this is chronology of case. The parties involved is judges Puan Rofiah Muhammad, plaintiff Puan Nofaizura Muhammad Ali, and defendant lawyer Jero representing the Nestle Manufacturing Malaysia Sdn Berhad. On 21 May 2019, the Nestle Manufacturing Sdn Berhad was charged for the first time in the Shah Alam court session with 1 charge of releasing industrial effluent in excess of the limit set in the hinterland. This company was pleaded guilty at the mention of the case. The court allocated a fine of up to 100,000 ringgit Malaysia or imprisonment for a maximum of 5 years or both. The lawyer Jero, who represented the company, asked the court to consider the sentence of the company. On 24 December 2000, this company was charged for the second time in the Shah Alam Session Court on 2 charges of discharging liquid waste into inland water under the Environmental Quality Industry Effluent Regulation 2009. On 26 December 2000, the accused Nestle Manufacturing Sdn Berhad Malaysia pleaded guilty after both charges were read out, and the company received a fine of 19,000 ringgit Malaysia. Type of offences. Offences 1. The charge failed to comply with the standard limit set out in the environmental quality. Offences 2 is alleged that the discharge of industry effluent excess the standard limit for one parameter under Regulation 12B, Environmental Quality Industrial Effluent Regulation 2009. Offences 3. The company was charged with repeated offences with evidence of 26 photographs and 4 bottles of sample linking the case of the defendant, OKS. To indicator, according to the charge, the company was found to discharge industry effluent in excess of the set limits into the interior at the Shah Alam complex, Jalan Playa 50/1 year between 10:10 a.m. and 1 p.m. May 21, 219. And the second is, the company also was found to discharge industry effluent in excess of the set limit into the interior at Shah Alam at the same time and the same place. At the court decision, firstly for the judge process. First, the court ruled that the company committed an offence under Regulation 11(1)B of the Environmental Quality Industrial Regulation 2009, which is punishable under Regulation 32 of the same regulation. The second is, the court also ruled that the company was also charged on another charge of an offense under Regulation 12B of the Environmental Quality Industrial Influence Regulation 2009 at the same place, time, and date. According to the two charged together with evidence of 21 photographs and 4 photos of sample relating to the case of the defendant, OGS, the Session Court allocated a fine up to 100,000 ringgit Malaysia or imprisonment for a maximum of 5 years or both. And the lawyer J. Rowe, who represents the company, asked the court to consider the sentence of the company. The accused, Syarikat Nestle Manufacturing Malaysia Sendirian Berhad, was pleaded guilty when the both cases were heard. The Hakim Puan Rofiah Muhammad at Session Court imposed a fine of 90,000 ringgit Malaysia on two charges of discharging liquid waste into inland water at the Shah Alam Complex, Jalan Playa 15/1.
Now, I will talk about the local cases number 2, which is paint manufacturing companies on the offence of committing environmental pollution. In the case overview, Inagro Sdn Bhd Company were ordered to pay the fine after pleading guilty to all 6 charges faced respectively. The Crown Sessions Court has imposed a fine of 190,000 ringgit Malaysia on a paint manufacturing company for polluting the environment in Jalan Kapar. It involved 5 charges under the Environmental Quality Act 1964 and 1 under the Environmental Quality, that is Clean Air, Regulation 2014, allegedly committed by Inagro at the premise in Jalan Kapar on 4 July 2019. In background case, which is the chronology of this case, the parties that involve the first plaintiff, which is Lim Yuk So, and then the judge is Hakim Razali Arifin, and the defendant is Inagro Sdn Bhd Company. On 4 July 2019, for the first charge, the premise was allegedly used the location for the recovery of scheduled waste, which is categorized as SW417 under Schedule 1, without a license. The court imposed a fine of 10,000 ringgit Malaysia on Inagro Sdn Bhd. And then, for the second charge, Inagro Sdn Bhd were each fined 5,000 ringgit Malaysia after making the designated premise for rehabilitation without the written permissions of the DOE, Director General under Section 19 of the same Act. We continue the chronology of this case. For the third charge, they were charged with carrying out the construction of a scheduled waste recovery plant without appointing a qualified person to conduct an environmental impact assessment and submit a report. So the court imposed a fine of 50,000 ringgit Malaysia on Inagro Sdn Bhd. And then they were also charged with contaminating the ground surface without a license with scheduled waste categorized as SW417, which is 5th and 6th charges, fines 10,000 ringgit Malaysia each for carrying out activities that create air pollution. Next, Inagro Sdn Bhd applied for reduced sentence due to several factors. So Judge Razali Arifin then imposed a fine of 190,000 ringgit Malaysia on the company. In this slide, we show about the type of offence and indicator. So for the offence, the first is using a location for scheduled waste recovery categorized as SW417. The second, making the designated premise for rehabilitation without the written permissions. The third, carry out the construction of a scheduled waste recovery plant without appointing a qualified person. Number 4, contaminating the ground surface without a license. And then the fifth, carrying out activities that create a source of air pollution emissions. And then, what is the indicator? So the first is categorized as SW417 under Schedule 1 Environmental Quality Regulations 1974. Second, submit a report to the Director General of DOE as provided under Section 34A of the Environmental Quality Act. And then the third is waste of ink, paint, pigment, lacquer, dye or varnish categorized as SW417. So for the court's decision in this case, Hakim Razali Arifin, as a judge at the Klang Session Court, then made the final decisions by imposing a fine of 190,000 ringgit Malaysia on the paint manufacturing company Energo Sinar Berhad for the offence of polluting the environment of the premise at Jalan Batu Kapar.
Assalamualaikum Puan, I'm Balkis will be the third presenter to explain the international case, the dispute between Link versus Northwest India Cemetery Protective Association. This is the review case. This case is landmark case in which the United States Supreme Court decided whether the free exercise clause applied to religious practice. The Yurok, Karo and Tolowa tribes use this area specifically in the Chimney Rock area of California's Six Rivers National Forest, also known as the High Country, as a holy site. This Supreme Court views the decision as a notable example of judicial restraint. This case started when the United States Forest Service (USFS) produced an Environmental Impact Statement (EIS) in 1982 to propose route through the Six Rivers National Forest and perhaps harvesting timber. Since the area is considered sacred territory, the resulting harm will be severe and irreversible. Additionally, the EIS suggested possible alternative was route that avoided key religious sites. However, this recommendation and the rest of the report was rejected by the U.S. Forest Service. Then, Northwest India Cemetery Protective Association and the state of California filed a lawsuit seeking an injunction to stop the road construction and wood harvesting. The court ordered a permanent injunction prohibiting the government from erecting chimney rock, ruling that such act would violate respondents' Indians' rights under the First Amendment's Free Exercise Clause as well as federal statutes. Next, the United States Forest Service (USFF) filed an appeal. The appellate court upheld the decision, and then USFS appealed again, but this time to the United States Supreme Court. The petitioner Richard Edmund Link, the United States Secretary of Agriculture at the time, claiming that building a road and collecting timber across the site that considered as sacred by Native American tribes violated the First Amendment's Free Exercise Clause. With the claim in hand, the Supreme Court decided to rule on whether the government's harvesting or development of the Chimney Rock area was banned by the First Amendment's Free Exercise Clause. The court's decision was issued on April 19, 1988 after much consideration. The court concluded that building of the planned route does not violate the First Amendment because it required no activity contrary to their belief. In a vote of 5 to 3, Justice Sandra Day O'Connor supported the ruling by citing Bowen versus Roy, 1986. A previous United States Supreme Court case in which a family refused to give their kid a social security number for religious reasons. Based on these similarities, Justice O'Connor concluded that while the construction and harvesting will certainly cause damage to the area, the project will not force individuals to violate their belief or deny them the same right as other citizens. The Supreme Court had decided whether a government action would impose a substantial burden on religion in order to reach a decision. Substantial burden exists only when the government imposes a sanction, fine or imprisonment, or denies individual benefits. However, neither of the factors were present in this case. Justice William J. Vernon Jr. objected with the majority opinion, claiming that the ruling in Link robs Native Americans of their constitutional protection against threats to their religious practices, citing the case Sherbert versus Vernon, 1963. The final decision, U.S. Supreme Court overturned the decision and permitted the route to be completed. The Supreme Court, citing Bowen versus Roy 1986, held that free exercise clause protect an individual against certain sorts of government compulsions, but it does not provide an individual the right to detect how the government conduct its internal procedure.
In conclusion, based on our understanding of case number 1, any individual or organization involved with an environmental crime case will not be able to avoid facing punishment. Although there is no direct evidence linking the Nestle manufacturing number hype with pollution to the Klang River, the company's action could have an impact on the environment. Indeed, this act of pollution brings disaster to the environment. It doesn't involve us, but affects future generations. Furthermore, in local case number 2, which is paint manufacturing company offence of committing environmental pollution, our conclusion is any work of painting the ground and floor using waste ink, paint, pigments, liqueurs, dyes, or varnish should be carefully identified in advance of material that are safe to us. So, in our opinions, that any activity we want to do needs to emphasize on what the impacts it will be on the environment around us to prevent dangerous disease affected the health of public and at the same time environmental conditions will be well preserved. Moreover, in the international case, show that question of religion and development for the common good is a separate issue. Although the United States government protects religious freedom under the First Amendment free exercise clause, this doesn't mean that a believer's right to practice their faith is unassailable. Citizens must follow regardless of religion, race, or skin color for the sake of making a country stable and successful. This also demonstrates that as students we have the right to follow the legislation that have been established and to comprehend the essence it contains so that we can act appropriately as if something occurs. That's all from us by Group 11, and thank you.